So, starting with some basics, which I'm sure are completely familiar to you. A contract for the sale of an interest in land or other disposition of an interest in land is void unless it complies with Section 2 of the Law of Property and Miscellaneous Provisions Act of 1989. And the provisions of Section 2, I'm sure, again, will be very familiar. The contract must be in writing. It must contain or incorporate all of the terms expressly agreed by the parties in one document, or where contracts are exchanged, of course, is conventional in both parts, and it must be signed by or on behalf of each of the parties to it. Now, the application of Section 2, one most commonly comes across it in the context of contracts for the sale and purchase of land, also agreements for lease, agreements for surrender, and variation of any contracts of those other three sort. But it applies to any agreement for the disposition of any interest in land. Now, some contracts are accepted from it, so contracts for the grant of a short lease falling within Section 54(2) of the Law of Property Act 1925, contracts made in the course of an auction, and also Section 2, subsection 5 provides that the creation or operation of resulting, implied, or constructive trusts are unaffected. And of course, that is something which is quite often argued when people are trying to get around the requirements of Section 2. One more example is a slightly earlier one, the case of Next PLC and NFU Mutual Insurance. That was in 1997. And this really is, I think, kind of the high watermark or even the low watermark of these sorts of cases. Taken in the context of the surrounding circumstances and correspondence, the consent the court considered consisted of a letter headed subject to license containing the words, "I have now instructed our solicitors to issue a draft license," followed by the submission of a draft license. Now, the tenants there were after not only a declaration that landlord's consent had been granted, but also an injunction requiring the landlord to execute the license in the form which had been agreed. So the outcome was not that the landlords failed to secure the required license, but that they couldn't prevent the assignment. Their objection being that information had come up late in the day which cast serious doubt over the assignee's financial position. In normal circumstances, that would be a legitimate reason for refusal of consent. But in this instance, it was too late. They'd already consented.